Good afternoon. This is the first video about company law. As we have talked this morning, on Friday we are going to have a meeting through Teams, and then we are going to discuss about the contents of this video, and then we are going to move to the next step in company law. Company law from the international point of view, from the point of view of international commerce law. All of you know what a company is. A company is a legal entity, a company is subject to legal duties, and a company is entitled to have legal rights. It's like a person, like a man or a woman, but a legal fiction. In the same way that a physical person is able to own property, and it's able to have rights, and it's obliged by duties, a company is also able to have rights to be obliged and to own property. But it's a fiction, it's a legal fiction. The idea is that a group of persons from certain point, they are not going to act in the commerce as physical persons, but as a new entity, the company. Of course, all of you know this, and all of you also know that there are two main kinds of companies. Well, there are many kinds of classifications of companies. There are many distinctions between companies, but I think, and for our purposes, it's the most important. The main division is between companies with limited liability of partners and companies with unlimited liability of partners. The distinction, I think that it's clear. In companies with unlimited liability of partners, the personal assets of the partners can be affected by the debts of the company. That means the company is a legal entity. The company enters into contracts, into relationship with another merchants, with people in the commerce, and the company can be obliged by debts. When a company has a debt, it's the same that a physical person. The company must pay the debt, and the company has assets, has money, has maybe lands or factories, and all these companies' assets are liable by the company's debts. And the creditors can use these companies' assets to obtain the payment of the debts the company has with the creditors. But what happens when the company assets are not enough to pay the debts of the company? Well, in companies with unlimited liability of partners, the personal assets of the partners must respond for the company's debts. This is important. The personal wealth, the personal assets of the partners of the company are not free, can be affected by the company's debts. In companies with limited liability of partners, the situation is completely different, because in this kind of companies, when the company's assets are not enough to pay all the debts of the company, the creditors cannot act against the personal assets of the partners. The personal assets of the partners are not affected by companies' debts. And of course, this is very important. It's not the same to enter into business knowing that your personal wealth, your personal assets can be affected by the company's debts, that enter into business knowing that you can lose the money you are investing in the company, but your personal assets cannot be affected by the company's debts. So this is, I think, a very important distinction, and we are going to see the consequences from the point of view international arena in some minutes. This is the first idea. Companies, legal entities, they are entitled to legal rights, and they are subject to legal duties. They are as physical persons, but fictions, legal fictions. And a very important distinction between companies is companies with limited liability of partners and companies with unlimited liability of partners. Other idea we have to consider is that companies are not the same in all the countries. I mean, if we take a look to the Spanish company law, we see that in Spain we have limited liability companies, what in Spanish is called sociedades de responsabilidad limitada, joint stock companies, sociedades anónimas, or limited partnerships, sociedad comanditaria por acciones. These are the main types of companies in Spain. But if we are going to the United Kingdom, then we see different kinds of companies. We have private companies, kind of companies that cannot make public offers, and public companies that should have at least a capital of £50,000 sterling, and these companies can make public offers to the public. So we see that it's not the same kind of companies in Spain or in the United Kingdom. They could be similar in some way, but from a strict point of view, these are different kinds of companies. If we move to France, we see also different kinds of companies. In France, we have private companies. In France, we have Société à responsabilité limitée, or something like that in French, sorry for my French, and Société par actions, with a minimum capital of 37,000 euros. And within this kind of companies, Société par actions, we found Société Anonyme, Société Anonyme Simplifiée, Société en commandite per actions, very similar to the Spanish limited partnerships, so different kinds of companies in France. And finally, in Germany, we have Gesellschaft mit beschränkter Haftung, GmbH, that is very similar to the Sociedad de Responsabilidad Limitada in Spain, Société à Responsabilité Limitée in France, Aktiengesellschaft, Sociedad Anónima in Spain, and Kommanditengesellschaft auf Aktien, that is very similar to Sociedad Comanditaria por Acciones in Spain. So, these are different kinds of companies in different countries. And we are in international commerce law. And the people who are really working international commerce law, the players in international commerce law, are companies. But companies are companies from one country. So, I mean, We are working in international arena, but the players are national companies, companies created according with the law of one country. And it's not the same a company created in Spain, incorporated in Spain, than a company incorporated in France or a company incorporated in Germany. We are working in the international arena, in international commerce, with companies incorporated in countries, in national countries. We have also European Union companies. We are going to see that in the next video at the end. But really, they are not very important in international commerce. The most important players in international commerce are companies incorporated in countries, in countries like Spain, Italy, Portugal, United States, etc. And so this could be a problem. Maybe we're going to see that in some minutes. We have international commerce and we have national companies. And which are the problems we are facing in international commerce in relation with companies? Well, there are three main problems. Recognition of foreign companies, lex societatis, and nationality of companies. At this point, we are going to consider that nationality of companies and lex societatis is the same problem. We are going to deal with this problem in a moment. But we are going to start with the other problem. Three problems: recognition of foreign companies, lex societatis, nationality of companies. Nationality of companies and lex societatis, we are going to consider that it is the same problem, and we are going to begin with recognition of foreign companies. That is I think, the main problem in international company law, recognition of foreign companies. What does it mean? What does it mean, recognition of foreign companies? Well, the first is that, as we have seen, a company is a legal fiction, is created according with one law, the law of one country, and of course, as a legal fiction, that company exists from the point of view of that country, from the point of view of the country in which the company was incorporated. If we are creating a company according with German law, from the point of view of German law, that company exists. But what happens from the point of view of other countries? We have a company incorporated in Germany, but what happens with that company from the point of view of Spain or from the point of view of France or Canada? Well, it's a legal fiction, and if one country different of the country where the company has been incorporated allows to act this company as a legal entity, this company, this law, the law of a country different than the country in which the company was incorporated, can introduce, this law can introduce some requirements that must be fulfilled by the company if the company wants to be recognized in that country. The law of the country where the company wants to operate could require requirements of the company to recognize the legal entity. Which requirements? Well, mainly, but first, before entering into the requirements, And what happens if the requirements are fulfilled? Well, if we have a company incorporated in a country, Germany, for example, and this company wants to operate, to do business in another country, for example, Russia, and the company fulfills the requirements of the Russian law, then from the point of view of Russia, this company, this German company incorporated in Germany, will be considered as as a legal entity, also from the point of view of the Russian law. From the point of view of the Russian law, this is a German company. It's not a Russian company, it's a German company. But the Russian law will say in some way, well, we admit that there is a legal entity incorporated in Germany, and we are going to allow that legal entity to do business in Russia. When the requirements are not fulfilled, then this other country, different than the country where the company was incorporated, is not going to recognize the company, and so from the point of view of that country, the company simply doesn't exist. When the German company wants to, for example, demand the registration of a branch in that country, Russia in the example we are using, the Russian authorities simply are going to say, well, you don't exist. I'm a German company. Well, you are a German company from the point of view of the German law, but from the point of view of the Russian law, you simply don't exist. This is your problem. You don't have existence from the point of view of our country. We can consider some of the consequences of this non-existence of the company, but we are not going to enter into this problem now. I want only to stress this idea. The company exists from the point of view of the country where the company was incorporated, but when the company doesn't fulfill the requirements of another country for being recognized, then this company, from the point of view of that other company, of that other country, simply doesn't exist. This is the idea. And now, which are these requirements? Well, at this moment, the main requirement is that the company should have been created, incorporated, according with the law of the country where the company has its real seat. I'll repeat. The main requirement for the recognition of foreign companies is that the incorporation of the company, the creation of the company was made according with the law of the country where the company has its real seat. We are going to see that now more in detail. First, real seat. What does real seat mean? Well, there are different meanings of real seat, but usually real seat means main administration, the place where the decisions about the life of the company are adopted. When there is a group of persons ruling the company, a body that governs the company, where this group of persons meets, where the decisions about the company are adopted, this is the place where the main administration is located, and so is the place where we find the real seat of the company. This is the idea. This is the real seat of the company. The real seat of the company, I repeat, is usually we consider as real seat of the company the place where the company, where the decisions about the life of the company are adopted. This is the real seat of the company. And the requirement I was explaining is that the incorporation country, the country in which the company has been created, should be the country in which the real seat of the company is. So, if we have a company incorporated, for example, in the United States, but its real seat is in France, so in a country following this approach, including this requirement about the recognition of the company, in this country, the company incorporated in the United States is not going to be recognized. I repeat the idea. We have a company, for example, incorporated in the United States, but this company has its real seat in France. If we are considering the problem from the point of view of a country that includes the requirement for the recognition of the foreign companies, that this foreign company should have its real seat in the country of incorporation, as in this case, this is not happening because the incorporation country is the United States and the real seat of the company is in France. From the point of view of that country, the company doesn't exist. This is the idea. The company doesn't exist because the company incorporated in the United States is not fulfilling the requirement included in the country of the recognition of the company, because there is a dissociation between the country of incorporation and the country of the real seat of the company. We are going to go back to this idea now. Don't worry, at this point there is something that is not clear, and one of the advantages of having a video is that you can go back and go forward as you need. But the idea at this moment is that, I repeat, the company exists in the country where the company was incorporated. The company, for being existing in another country, should fulfill the requirements required by this country, and the main requirement is that the country of incorporation of the company and the country where the real seat of the company is should be the same country. And when a country includes this requirement in its international company law, no company incorporated in a foreign country and that doesn't fulfill the requirement will be recognized. But there are countries that include this requirement in its international company law, and there are countries that don't include this requirement in its international company law. I mean, there are countries in which no foreign company is recognized when there is a dissociation between the country of incorporation and the country where the real seat of the company is, and there are countries where this requirement is not necessary for the recognition of the foreign company. In these countries that don't require the coincidence between the country of incorporation and the country of the real seat of the company, the only requirement for the recognition of a foreign company is that the company was legally incorporated in the country of incorporation. And it's not important which country is this, the country of incorporation. In countries following this approach, the only requirement is that the company has been, in the moment, legally incorporated. But when this incorporation was legal from the point of view of the country of incorporation, the country the company is going to be recognized, even in the case that the real seat of the company is not in the country of incorporation. So look at the difference. Some minutes ago, we were talking about a company incorporated in the United States and with real seat in France. Now we are going to consider a country following what we call the real seat theory. That means countries that in its international company law includes the requirement that the real seat of the company must be in the same country than the country of incorporation. For example, Germany. Germany follows this approach. So in Germany, foreign companies are not recognized when they were incorporated in a country different than the country of the real seat of the company. In that case, a company incorporated in the United States and with real seat in France, this company, from the point of view of the German law, doesn't exist. This company cannot be recognized in Germany. But if we are considering the problem from the point of view of the United Kingdom is a country following the incorporation theory. That means, incorporation theory means that the foreign companies are recognized when they were legally created, incorporated, even in the case that incorporation was made in a country different than the country where the real seat of the company is. This is a country following the incorporation theory. So, as the United Kingdom is a country following the incorporation theory, this company incorporated in the United States and with real seat in France is going to be recognized in the United Kingdom. Because in the United Kingdom, they are not going to check whether the real seat of the company is or is not in the country of incorporation. For the United Kingdom, the only important fact is that the company has been rightly, legally incorporated in the country of incorporation, United States. When the company was legally incorporated in the United States, in this case, the company is recognized. And the fact that the real seat of the company is not in the United States but in France has no relevance. So this company is going to be recognized in the United Kingdom. So the same company is going to be recognized in the United Kingdom but not in Germany. This could happen. This happened in international commerce. We change the solution according with the point of view we adopt. And this is important. In international commerce, we always pay attention to the point of view we are adopting. They are no general and worldwide solutions. The solutions are always solutions from the point of view of one country. And in this case, we are talking about recognition of companies, and we always must say, well, we are considering the recognition of the company from the point of view of which country. We have a company, I repeat, incorporated in the United States and with real seat in France. And now we are going to deal with the recognition of the company. We are going to deal with the recognition of the company from the point of view of the United Kingdom, or are we going to consider the recognition of the company from the point of view of Germany? The solution will be different. If we adopt the position of the United Kingdom, the company is going to be recognized. If we adopt the position of Germany, the company is not going to be recognized. And this is important. It's important to realize that, and it's very important for international commerce. So, is that clear? I repeat, as we are going to have a meeting through Teams next Friday at 12. If you have doubts, we can comment these doubts on Friday. So incorporation theory and real seat theory. remember those concepts: real seat theory, countries in which foreign companies are not recognized when the company has been incorporated in a country different than the country of the real seat of the company. These are countries following the real seat theory. Incorporation theory. In these countries following the incorporation theory, companies are going to be recognized when this company has been legally incorporated in the country of creation of the company, even in the case that the real seat of the company is not in this country. These are the main difference between incorporation theory and real seat theory. And this difference between real seat theory and incorporation theory is related with the recognition of foreign companies. Remember, the first problem we are going to deal in international company law, recognition of foreign companies. And according with recognition of foreign companies, we have countries following the real seat theory and countries following the incorporation theory, and the differences between these two countries, these two kind of countries, is that in countries following the real seat theory, companies incorporated in a country different than the country of the real seat of the company are not going to be recognized, and following the incorporation theory, any company incorporated legally in one country is going to be recognized. But the differences between incorporation theory and real seat theory are not limited to the recognition of foreign companies. There is another point. Well, the point is that each company is linked to a law, the law of a country, and this law is the law who governs the creation of the company, but also, for example, the rights and duties of the shareholders, of the partners, the composition of the bodies of the company, the duties and rights of the directors of the company, and some other topics, some other questions related with the company. I repeat, a law that is connected with the company and that rules the main aspects of the company as creation and also dissolution, validity and nullity of the company, and rights and duties of the shareholders and partners, rights and duties of the directors, etc. And this is a specific, this is the law of one country. But which country? If we are talking about international commerce law and we are talking about companies connected with different countries, with several countries, we must determine which is this law that is going to rule the company. Well, this law ruling the company is called lex societatis. Latin means the law of the company, the law of the company. And the countries following the real seat theory, in those countries, the lex societatis, the law governing the company, is the law of the country where the real seat of the company is, where the main administration of the company is. So, in these countries following the real seat theory, the governing law of the company is the law of the country where the real seat of the company is placed. And countries following the incorporation theory, in those countries, the law governing the company is the law of the country where the company has been incorporated, has been created. And this is also a very important difference. So, and it's connected, but it's not the same that the difference we have seen before. First, we have seen that foreign companies incorporated in a country different than the country of the real seat of the company are not going to be recognized in countries following the real seat theory. That's a point. And companies legally incorporated in a country, even in the case that that country is not the country of the real seat of the company, are recognized in countries following the incorporation theory. And now we add another point to this, that in countries following the real seat theory, the law governing the company is the law of the country of the real seat of the company. And in countries following the incorporation theory, the law governing the company is the law of the country in which the company has been incorporated, created. This is another difference. And so we see that there are in the different countries two main approaches to international company law. And we are going to find countries following the real seat theory and countries following the incorporation theory. For example, Germany, France, Spain, Italy follow the real seat theory. So these countries are countries in which usually there are many exceptions, but in general, in these countries, the law governing the company is the law of the place where the real seat of the company is. And countries like the United States, United Kingdom, the Netherlands, Denmark, are countries following the incorporation theory. So that means that the law governing the company is not the law of the company, the law of the country where the real seat of the company is, but the law of the country in which the company has been incorporated. At the end, the law chosen by the founders of the company, the creators of the company, the persons, the physical persons usually creating the company, decided that they were going to create the company in country X, and this law of country X is the law of incorporation of the company, and in the countries following the incorporation theory, this law is the law that is going to govern the company. I hope that this is clear. If you have any doubt, please let me know. You can send me an email, you can demand a Skype conversation, and on Friday, as you know, we have this meeting at 12 o'clock. I'm going to share with you through Moodle the link to take part in the meeting on Friday. Then we can discuss, we can comment, we can add information about all these ideas. Is that okay? So we can move to the next point. And the next point is just to explain how we ended in this difference between incorporation theory and real seat theory, and which is the reason of the problem of recognition of foreign companies. And well, you know that I think that when there is something complicated, the best way to understand is to look at history. We have seen that in the first lesson of the course. We have also looked at history when we were considering patents. And I think that in international company law, we should take also a look at history. I think that this is the way to really understand the problems of international company law nowadays. So now we are going to take a look at the history of international company law. And I repeat, as always said, If we are looking at history, it's not to know things about something that has happened centuries ago. It's to understand how things are working now. I only use history to understand the problems we have now. It's not a trip for curiosity or erudition or something like that. No, it's just to understand the problems we are facing now. To take a look from another perspective to this distinction between real estate theory, incorporation theory, recognition of foreign companies, lex societatis, and all these things. And what does history teach us? Well, the first is that the first problem is recognition of foreign companies. And recognition of foreign companies is a relative new problem. Relative, because we are talking in historical terms, and in historical terms, 160 years is not a very long time. And this is the time in which we have the problem of recognition of foreign companies. I mean, before 1849, the problem of recognition of foreign companies simply didn't exist. What does it mean? Imagine 18th century. In the 18th century, there were companies. We are going to see that now in a moment. Companies incorporated in France, in the Netherlands, in Spain, in the United Kingdom. These companies were created by the law of those countries. And these companies acted in other countries. They had business in other countries. But nobody thought at that moment that the company couldn't be recognized. The idea of recognition was out of the frame. It was impossible to think in the non-recognition of a company. When the East India's company incorporated in the United Kingdom made business in Spain, for example, it was impossible to think that you are not going to recognize the company. If anybody at that moment said, well, but this is a foreign company, what do you think? Maybe the company is not existent here. The rest of the people will simply say, you are mad, you are crazy. Of course, the East India company exists. This is a reality, this is a fact. How are you saying that the company doesn't exist? Of course exists. It has been created in the United Kingdom, but of course exists. This was the situation before 1849. But in 1849, there was a decision of the Supreme Court of Belgium, and this decision established that a French company didn't exist in Belgium. And this decision of the Supreme Court said that what I said at the beginning of this video. A company is a legal fiction, and as is a legal fiction, exists only in the country where it has been created. Outside the borders of this country, the company didn't exist. And so the Belgian courts didn't recognize the French company. And that had consequences, because in that case, the French company was trying to introduce a claim before the Belgian courts, and as the legal personality of the company was not recognized, the action, the claim that company introduced in the Belgian courts ended. So the defendant could be could be very happy because the action intended against him by the French company couldn't arrive at an end because the French company, hadn't been recognized in Belgium. And so this was new because before that point, as I have said, nobody thought that a foreign company could not be recognized. And of course, that created a serious problem at the moment because we were in the middle of the 19th century and the Industrial Revolution was in a very, very high point, and the communication and the international activity of companies was very important. And to stop abruptly this relationship, this international relationship of companies, was very important at that moment. And after this decision of the Belgian court, of course, after that decision of the Belgian court saying that French companies are not recognized in Belgium, French courts decided that Belgian companies are not recognized in France, and Italian courts, well, Italian, at that moment Italy as a state didn't exist, but the courts in the nations that would after that were united, were joined in Italy, decided that French or Belgian companies are not recognized in Italy, and all the Italian companies were not recognized in the rest of the country. So a mess, a very huge mess. And at the end, the solution at that point, at the middle of the 19th century, was to reach agreements, to celebrate agreements between countries. In that agreements of establishment, each country assumed the obligation of recognizing the companies incorporated in the other country. For example, a treaty on establishment between France and Belgium. In a treaty like this, the French authorities assumed the obligation of recognizing the companies incorporated in Belgium, and the Belgian authorities assumed the obligation of recognizing the companies incorporated in France. And a lot of treaties between countries in Europe were writing at that moment in order to find a solution for the wrong recognition of companies. And the solution was this one, was that each country assumed the obligation of recognizing the companies incorporated in other countries, but because the other country assumed the obligation of recognizing the companies incorporated in the first country. And it's important to realize the reason of this problem and the philosophy of the solution at that point. This is the important point. Why? I think that it's not possible to understand what had happened at that moment in the middle of the 19th century if we don't pay attention to the differences between the incorporation, the creation of companies at that moment, and the creation of companies nowadays. Nowadays, how a company is incorporated. I assume that all of you have an idea of how a company is created. And the idea is that a company is created following the requirements of the law. And these requirements of the law differs country to country, but in most of the cases, the creation of the company requires the agreement between the founders of the company, and then there is a kind of contract between the founders of the company the founders of the company must agree on the rules governing the company, the in-laws of the company, and then the contract, the in-laws, the bylaws of the company are taken to an office in Spain, Registro Mercantil, in Germany, Handelsregister, in the United Kingdom, the Register of Companies. It depends of the country, but it's different in any country, in each country. But the founders of the company took these papers, the agreement, the bylaws, etc., and they present these papers to the authority in the Registro de Mercantil, Handelsregister, etc. And the authority at the register determines whether the contract, the bylaws, are according with the law or not. When the agreement and the bylaws are according with the law, then the authority registers the company, and the company has been born because the registration usually, and the authority of the register is limited to determine whether the legal requirements have been fulfilled or not. There is not a decision about the creation of the company. It's just to check whether the founders have created the company according with the law or not. This is the situation we have now. But in the first half of the 19th century, and before that, the creation of companies with limited liability of partners, this is important, capital-based companies, that means companies with limited liability of partners, that means capital-based companies, companies in which the personal assets of the partners are not affected by companies' debts. This was explained at the beginning of the video, and it's important now to take that into consideration. So, at that moment, this kind of companies, and it's important to stress that this kind of companies, capital-based companies, the companies with unlimited liability of partnership follow a different approach, but at that moment, companies with limited liability of partners were created by a political decision of the power, of the public power, the king, the queen, the government. So, when you want to create a company with a limited liability of partners, you should apply to the government, to the king or the queen, and then the king, queen, government decided, according with political reasons, whether they allow the creation of the company or not. It was, I repeat, a political decision. And in some countries, it was very difficult to create a company with a limited liability of partners. It was not easy. Usually, the public power denied the permission for the creation of a company with limited liability of partners. This is important this is important for our purposes to realize that. And it's a strong difference between the situation then and the situation we have now. It's a very, very important difference because, as we have seen and you know, nowadays there is no political decision about the creation of a company with limited liability of partners. when you fulfill the legal requirements, the company is created. There is no problem at all with that. But at that moment, there was not a right to create this kind of companies. I repeat, it was a political decision. And maybe you can ask, why? Well, the reason, there are two main reasons. One of the reasons is that at that moment, these kind of companies were created in order to exploit monopolies, public monopolies. Here you have the chart granted by the Queen Elizabeth of England, a chart issued the last day of the 16th century, in which the East India Company was created. And in that case, the creation of the company was joined to the fact that the Queen allowed that company to exercise a public monopoly, in that case the commerce with the colonies. As you know, because we have seen that in lesson 1, the commerce with the colonies was a monopoly, a public monopoly, and only people with the authorization of the public power could do this activity, the commerce with the colonies. And in that case, the creation of the company and the allowance to do the activity, in this case, to commerce with the colonies, were joint. And this is one of the reasons because the creation of the company was a political decision, because the decision of creation of the company was linked to the concession of the exercise of a public monopoly. This was one of the reasons. And the other reason is that at that time there were some doubts about this kind of companies. The idea is, when we have a company with unlimited liability of partners, so a company where the partners, the personal assets of the partners are affected by the company debts, then the partners are going to be very careful in which business they enter into. They are not going to use the company to do not very smart things. But when we have a company with limited liability of partners, so the partners who are ruling the company know that their personal assets are not going to be affected by the company debts, maybe they can use the company to enter into adventure not very wise, and this could be a risk for the rest of the people in the commerce. Maybe if we have a lot of companies with a limited liability of partners, they are going to enter into risky business, and another people is going to be affected by the insolvency of these companies, with the problems of these companies, and the personal assets of the partners are not going to be affected. So let's be careful with this kind of companies. This was the second reason why at that moment the idea of allowing everybody to create companies with limited liability of partners was this idea was not very popular between the public power, between the lawmakers. And this changed in the middle of the 19th century. And so we must consider why this have changed in the middle of the 19th century. But I think that the two first videos were very long, almost 1 hour and a half, and I have the purpose of making videos no longer than 1 hour. So I think that this is like the ring the bell ringing. We are almost in 1 hour, so I'm going to stop here, and we are going to continue in the next video. And I have said that I'm going to give you some case law of the European Union. Okay, I'm going to give you that case law, but as we haven't yet finished with this introductory part, really it's very short what we need, but we haven't finished yet. And I guess that you are preparing the examination of the next week. I'm going to give you the case law, but it's not necessary to read the case law for the meeting we are going to have on Friday. I prefer, I think that you are now studying unfair competition, patents, trademarks, and all these things. We are not going to add new case law in company law for this week. I'm going to give you the case law, but you are not compelled to read this case law. Of course, if you want, perfect, but you are not compelled to do that, because next Friday we are going to comment this video and the doubts you have about all the topics we have considered in lesson 2, and we are going to continue with company law in the next video, but I think that next week, after the practical exercise we have on Tuesday. And of course, on Friday, I will give you the link for the meeting we have at 12 o'clock. Have a nice week, and you can contact me through mail. Be careful, stay at home, and we see again on Friday at 12 hours.